Every single time you buy a firearm from a licensed dealer, you fill out the same federal form, and buried in that form is one question that has quietly disqualified hundreds of thousands of otherwise law-abiding Americans from ever completing the purchase. Not a felony conviction, not a domestic violence record, a single yes or no question about marijuana. That question is now changing because of a Supreme Court ruling and a federal rescheduling decision that are reshaping it at the same time. And if you're planning to buy a firearm anytime soon, you need to understand exactly what's changing, what isn't, and where the real legal risk still sits. Think about how many people this single question actually touches. Marijuana is legal in some form, medical or recreational, in a large majority of states at this point. That means millions of Americans are, right now, using a substance their own state has explicitly authorized, while a single question on a federal form treats that exact same conduct as an automatic disqualifier from a constitutional right. For years, the honest answer to that question, if you used marijuana at all, was that answering truthfully meant the sale couldn't proceed, and answering falsely meant committing a separate federal felony the moment you signed your name. That's the exact bind millions of gun buyers have quietly been navigating, often without fully understanding the stakes. And it's the bind this year's developments are finally starting to unwind, piece by piece. Let's walk through the actual form, the actual ruling behind the change, and exactly what you need to know before you sign that form under penalty of perjury, because getting this wrong isn't a paperwork mistake, it's a federal crime. Before we get into it, one thing. This channel covers ATF policy changes and Second Amendment rulings the moment they happen, not weeks later once the confusion has already spread at the gun counter. If that's the kind of information you want in your corner, subscribe right now and hit the bell. It costs you nothing, and the next update on this exact form will be waiting for you the moment it happens. Let's start with the form itself, because most people who've bought a firearm have filled this out without necessarily thinking hard about the specific language, and that language matters enormously right now. ATF Form 4473, officially the firearms transaction record, is the document every buyer completes at a federally licensed dealer before a firearm purchase can proceed, feeding directly into the background check process. For years, the form has included a specific question asking whether the buyer is an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance, paired with an explicit warning that the use or possession of marijuana remains unlawful under federal law, regardless of whether it's been legalized or decriminalized for medicinal or recreational purposes in the buyer's home state. Answer yes, and the sale doesn't proceed. Answer no while actually using marijuana regularly, and you've committed a separate federal crime, lying on a federal form, regardless of what happens with the underlying possession question. That's exactly the legal trap millions of Americans have been caught in for years, especially as more states have legalized marijuana for medical or recreational use, while it remained fully illegal at the federal level. You could be completely compliant with your state's law, using marijuana exactly as your state permits, and still be federally barred from legally purchasing a firearm, with the form itself spelling out in plain language that your state's legalization doesn't matter one bit to the federal question. Two separate developments this year are now changing that picture, and understanding both of them and how they interact with each other is the key to understanding where things actually stand right now. The first is a Supreme Court ruling. In United States v. Himani, decided June 18th, the justices ruled unanimously, 9-0, that the federal law barring gun possession by unlawful drug users violates the Second Amendment when applied to a regular but non-dangerous marijuana user. The case involved a Texas man who told federal agents he used marijuana about every other day. Federal agents had actually searched his family's home over an unrelated suspicion involving terrorism-related activity, an investigation that led nowhere, no terrorism charge was ever filed, and no drug trafficking charge followed either. He cooperated fully, surrendered a handgun kept in the house, and told agents about his marijuana use. More than 6 months later, based solely on that admission, the government charged him under the federal statute with possessing a firearm while being an unlawful drug user. The government prosecuted him under the federal statute anyway, without alleging he was ever impaired while handling a firearm, without alleging addiction, and without alleging any violent conduct or threats. Justice Neil Gorsuch, writing for the court, rejected the government's position sharply, writing that affording the government broad power to designate any group as dangerous, and thereby disqualify its members from having a gun, would risk allowing it to quickly swallow the Second Amendment entirely. The ruling was genuinely unanimous, all 9 justices, though several wrote separately to stake out narrower or broader positions on exactly how far the underlying reasoning should extend in future cases. The second development is administrative rather than judicial. In April, the acting attorney general issued an order rescheduling marijuana products regulated under a state medical program, along with FDA-approved marijuana products, moving them from Schedule 1 to Schedule 3 under the Controlled Substances Act. That's a significant regulatory shift in how the federal government classifies marijuana generally, separate from the Himani ruling but happening at almost exactly the same time, and it's directly shaping how ATF is now rewriting the actual language on Form 4473. Let's talk about what ATF has actually proposed changing on the form itself, because the specific wording matters enormously here. Back in May, before the Himani ruling even came down, ATF posted a draft revised version of Form 4473 in the Federal Register. The current form's warning states plainly that marijuana use or possession remains unlawful under federal law, regardless of whether it's legalized or decriminalized for medicinal or recreational purposes in the buyer's state. The proposed revision removes that blanket language entirely and replaces it with a narrower warning stating simply that federal law does not permit the use or possession of marijuana for recreational purposes. Notice what's missing from that new language: the word medicinal. That's not an accident or an oversight. It's the form catching up to the rescheduling order, acknowledging that state-licensed medical marijuana patients using cannabis exactly as authorized under their state's medical program now occupy a meaningfully different legal position than recreational users, at least as far as ATF's own proposed guidance is concerned. A gun rights advocate involved in tracking this closely said the revision means no state-legal medical cannabis patient would any longer have to choose between their medicine and their constitutional right to bear arms, assuming the proposed rule is ultimately adopted. Here's the critical detail you absolutely cannot afford to miss, and it's the single most important practical point in this entire video. That revised form is a draft. It has not been finalized. As of this recording, it remains open for public comment, with that comment period stretching out for months, until ATF formally finalizes and adopts a new version of the form. The current form, with its broader medical and recreational warning, remains the legally operative document at every gun counter in the country. That means right now, today, if you walk into a federally licensed dealer, you are still filling out the old form, with the old warning, regardless of the Himani ruling, and regardless of the rescheduling order. Do not walk into a gun store assuming the form has already changed just because you've heard about the draft revision. It hasn't, not yet, and answering the current form's questions incorrectly based on an assumption about a rule that isn't finalized yet is exactly the kind of mistake that creates serious federal criminal exposure. Now let's talk about how the Himani ruling and the form itself actually interact, because this is genuinely more complicated than either extreme version of the story you're likely to hear. The Himani ruling addressed a criminal prosecution, a case where the government tried to prosecute someone under the federal statute based on marijuana use alone, without any additional showing of dangerousness or impairment. What the ruling did not do is rewrite Form 4-73, create an automatic safe harbor for marijuana users purchasing firearms, or eliminate the underlying federal statute the form is built around. The statute, 18 U.S.C. Section 922-3, remains fully on the books. What changed is that the government can no longer rely on marijuana use by itself, without more, to sustain a prosecution or, by clear extension, to justify denying a purchase. That distinction matters enormously in practice, because Form 4473 isn't just about criminal prosecution risk after the fact. It's about what you attest to under penalty of perjury at the moment of purchase, and that attestation obligation hasn't been formally updated to reflect the ruling yet. Legal experts closely tracking this issue have been direct about the practical risk here. The safest course, as multiple firearms attorneys have put it, is not to treat Himani as a green light to walk into a gun store and answer the form casually. The ruling gives an occasional, non-impaired marijuana user a much stronger legal argument if they're ever prosecuted down the road. But the purchase process itself remains legally uncertain until ATF actually finalizes updated guidance applying the ruling directly to the form and the background check process. Let me walk through exactly what this means depending on your specific situation, because the honest, practical answer here really does depend on the details of your own use. If you're a state-licensed medical marijuana patient, using cannabis exactly as authorized under your state's medical program, you're in the strongest position of anyone affected by this issue. The rescheduling order and ATF's own proposed form revision both point toward recognizing your situation as meaningfully different from recreational use, and once that revised form is finalized, it's expected to remove the disqualifying language for medical patients specifically. Until that happens, though, the current form's broader warning technically still applies to you, which is exactly the kind of gap between where the law is heading and where the law currently stands that creates real, practical uncertainty for anyone trying to do this exactly right today. If you're an occasional recreational marijuana user, someone using cannabis socially a few times a month, without impairment while handling firearms, without any history of violence or threats, and without addiction, the Himani ruling gives you a genuinely strong legal argument that marijuana use alone cannot constitutionally disqualify you from firearm ownership. But that legal argument is most relevant if you're ever prosecuted after the fact for possessing a firearm. It doesn't change what the current Form 4473 asks you to attest to at the point of purchase, and the form's current language doesn't distinguish between occasional and heavy recreational use the way the Himani ruling's reasoning ultimately does. If you're a regular heavy marijuana user, or if there's any indication of addiction, impairment while handling firearms, or any history of violence or threats, understand clearly that Himani was specifically framed as a narrow ruling. The court went out of its way to say its decision did not address the possibility of disarming people who are addicted, people who are presently intoxicated, or prosecutions supported by individualized proof that someone's drug use renders them dangerous to themselves or others. If any of those categories describes your situation, this ruling provides you meaningfully less protection than it provides someone who uses cannabis occasionally and without any of those additional risk factors. Let's talk about what ATF has said about its own process here, because the agency's own public statements give you a sense of the realistic timeline for when actual clarity might arrive. Following the Himani ruling, ATF stated publicly that it was reviewing the decision and assessing its impact, with additional guidance to be provided, in the agency's own words, soon. That's a genuinely vague timeline, and it reflects the fact that ATF now has to reconcile 3 separate moving pieces at once: the pre-existing statute still on the books, the rescheduling order affecting how marijuana is classified federally, and the Hamani ruling narrowing how the statute can be constitutionally applied. Getting all three of those pieces to line up in a single, legally sound revised form and a matching set of background check procedures is not a quick administrative task, and the agency's own public comment period for the draft form revision runs for months before any final version can even be adopted. It's also worth noting that this isn't the first adjustment ATF has made in this area recently. Separately from the Form 4473 revision, the agency issued an interim final rule earlier this year narrowing the regulatory definition of what counts as an unlawful user of a controlled substance, adding language clarifying that isolated or sporadic use isn't enough to trigger the prohibition, and that a single incident of past use doesn't automatically count either. That interim rule was itself open for public comment through the end of June, meaning ATF has multiple overlapping regulatory processes moving at once, on different timelines, all touching this same underlying issue. Think about what that interim rule actually does in practical terms, separate from the form itself. Historically, the definition of unlawful user had been applied broadly enough that even someone who admitted to using marijuana once, months earlier, could potentially be swept into the disqualifying category if that admission surfaced during a background check or investigation. The interim rule attempts to narrow that definition so it more accurately targets people whose use is regular and ongoing, rather than treating any historical mention of use, however isolated, as an automatic lifetime disqualifier. Combined with the form revision and the Hamani ruling, this represents ATF trying to bring three separate regulatory and legal threads into alignment at roughly the same time, which is part of why the overall picture right now feels more complicated than a single clean announcement would be. Let me walk through a few practical situations, because the legal nuance here only becomes useful once you connect it to an actual decision you might be making at an actual gun counter. Situation 1. You're a state-licensed medical marijuana patient walking into a dealer today, before any revised form has been finalized. You need to answer the current form's question honestly, based on the current form's actual language, not based on a draft revision that hasn't taken effect yet. If you're genuinely uncertain how your specific situation should be characterized under the current form's language, that's exactly the kind of question worth raising directly with a firearms attorney before you sign anything under penalty of perjury, rather than guessing based on news coverage of a proposed change. Situation 2. You're an occasional recreational user in a state where marijuana is legal, and you're wondering whether the Hamani ruling means you can now safely answer no to the form's substance use question. This is genuinely one of the most legally uncertain areas right now, and multiple attorneys tracking this issue have specifically warned against treating the ruling as a green light for how you fill out the current form. The ruling protects you if you're prosecuted after the fact for possession, but the form itself hasn't been updated to reflect that distinction yet, and a false statement on a federal form carries its own separate criminal exposure, regardless of how the underlying possession question eventually gets resolved. Situation 3. You're a firearms dealer trying to figure out what guidance to give your own customers while all of this is still in flux. Multiple gun shops have said directly that until ATF issues updated guidance on how Hamani affects background check procedures, form processing, and dealer responsibilities, they intend to continue following existing protocols rather than trying to anticipate a rule that hasn't been finalized. That's a reasonable, conservative approach, and it's worth adopting the same posture as a buyer, following the current rules as written while staying informed about when the actual updated guidance finally arrives. Situation 4. You work in the marijuana industry, perhaps as licensed security personnel at a dispensary, and you're wondering whether any of this affects your ability to be legally armed on the job. This is a genuinely more complicated question than the basic purchase issue, because it involves separate state licensing requirements on top of the federal firearms questions we've been discussing, and neither the rescheduling order nor the draft form revision directly resolves that specific overlap. If this describes your situation, it's worth getting guidance specific to your state's security licensing rules, in addition to the general federal picture we've covered today. Situation 5, and this one is worth understanding even if marijuana isn't your particular concern. Everything we've discussed today has focused specifically on marijuana, because that's where the Himani ruling, the rescheduling order, and the form revision are all concentrated right now. But Form 4473's question covers other controlled substances too, depressants, stimulants, and narcotics generally, not just marijuana specifically. The Himani ruling's core reasoning, that the government can't rely on substance use alone without an individualized showing of dangerousness, is written broadly enough that it could eventually be extended to challenges involving other substances as well. But as of right now, the ruling and the regulatory changes we've discussed are specifically tied to marijuana, and it would be a mistake to assume the same protections automatically extend to other controlled substances without a separate legal basis for that extension. Let's address a few things you're likely to hear about this topic that aren't quite accurate, because the noise here tends to run well ahead of the actual state of the rules. You may hear that the Himani ruling means marijuana users can now buy guns with no legal risk whatsoever. That's a significant overstatement. The ruling narrows how the government can prosecute simple possession based on marijuana use alone, but the underlying federal statute remains fully in place. The current Form 4473 hasn't been updated yet, and the ruling specifically preserved the government's ability to prosecute cases involving addiction, impairment, or individualized evidence of dangerousness. You may hear that the revised Form 4473, with its narrower recreational use warning, is already in effect at gun counters right now. It isn't. As of this recording, it remains a draft undergoing public comment, and the current, broader form is still the legally operative document until a final version is formally adopted. You may hear that marijuana has been fully legalized at the federal level because of the rescheduling order. It hasn't. The rescheduling order moved certain state-licensed medical and FDA-approved marijuana products from Schedule 1 to Schedule 3, a meaningful reclassification, but recreational marijuana use remains federally unlawful, and the broader question of full rescheduling for all cannabis products was still the subject of ongoing administrative hearings as of this recording. Here's what I want you to take away from all of this, because if you remember a few things from this video, remember these. First, Form 4473 still contains its original, broader marijuana warning right now, today, at every licensed dealer in the country. A revised version narrowing that warning to recreational use only has been proposed by ATF, but it remains in a public comment process and hasn't been finalized. Second, the Himani ruling is a genuine, significant win for occasional, non-impaired marijuana users facing federal prosecution for firearm possession, but it did not rewrite the form, did not eliminate the underlying statute, and specifically preserved the government's ability to prosecute cases involving addiction, impairment, or individualized evidence of dangerousness. Third, until ATF formally finalizes updated guidance connecting the Himani ruling, the rescheduling order, and the actual language on Form 4473, the safest practical approach is to follow the current form exactly as written, answer honestly based on your actual situation, and consult a firearms attorney directly if you have any genuine uncertainty about how to characterize your own use under the form's current language, rather than guessing based on how any of this might eventually be resolved. This is a genuinely fast-moving regulatory picture, with multiple overlapping processes at ATF working through their own separate timelines, and the practical rules at the actual gun counter are very likely to keep shifting over the coming months as these pieces come together. If you want to know the exact moment ATF finalizes this form and issues its actual updated guidance, subscribe and turn on notifications, because that update is going to matter immediately and directly to millions of Americans the moment it happens. Drop a comment and tell me whether you think the federal government should fully defer to state marijuana laws when it comes to firearm purchases, or whether you think a federal standard should stay in place regardless of state law. I read every comment, and I want to know where you land on this. Thanks for watching, and I'll see you in the next one.